we're joined by Wits University professor and media ethics expert Franz Kruger. He's going to talk us through some of the technicalities that involve the media during the Oscar Pistorius trial so far. Thank you for joining us, Professor Kruger.
Thanks very much. It's great to be here.
Day 2 got off to a very interesting start when a local media house broadcast a still image of one of the witnesses, Michelle Berger. Can you talk us through what happened and what the ethical implications there are?
Well, as you know, last week or so, the media secured an agreement from the High Court that that set out various rules around the live broadcasting of the trial. I mean, the details of that don't particularly matter here, but essentially there is an audio feed that is available to people to listen to the whole testimony. And there are extracts being broadcast on television, and there are various other rules around stills, photographs, and so on. The main point here is that an aspect of that ruling was that witnesses, particularly non-expert witnesses, would be entitled to refuse to have their images broadcast. They were required to tell the judge, the presiding judge, a day before, that they didn't want to have their images broadcast. They needed to give some good reason, and then the court would accede to that. To my knowledge, the witnesses that have taken the stand so far have all indicated that they're not keen to have their images broadcast. What happened was that a newspaper and a television channel took a very literal reading of that and decided that they were not broadcasting the image, the footage of the witness on the stand, but independently found images elsewhere, I think on Facebook, of particularly the first image, and used that to illustrate the television newscast and ran it in the newspaper. There were objections raised in court, and I think the view was taken that this was perhaps not a literal infringement of what had been ordered, but certainly it broke the spirit of the order. And certainly ENCA, the television channel involved, very quickly backed off, apologized, removed the image. So that is what happened. And I think from now on it will be clear that that prohibition applies also to images obtained elsewhere, not from the actual courtroom.
To your mind, was Judge Dunstan Njambo's ruling ambiguous in any way? And what is the responsibility of media houses to uphold the spirit of the ruling?
Well, I think the circumstances are really extraordinary. I mean, I don't think we've seen a court case that has such enormous, such a high profile internationally and domestically. I think that under the circumstances, the kind of agreement that was made with the court was a very careful one. And I think it is important for the media to, in a sense, adhere to the spirit of it. And I think in general, certainly in these sorts of areas, I mean, I think the media is very concerned not to queer its pitch, because of course, as others have pointed out, the judge's finger is on the button, and she can pull the plug entirely on this operation at any moment. So I think, the media do need to be careful, do need to adhere to the spirit of it. Was there ambiguity? One would need to look at the text initially. Certainly the ENCA version was that it was an honest mistake initially.
During today's proceedings, a witness, Charles Johnson, mentioned that his cell phone number was read out during proceedings yesterday, and he proceeded to get all manner of threatening phone calls from all around the world. What is the media's responsibility in protecting things like phone numbers, addresses?
I mean, to the extent that the media, has control over that kind of thing, I think there is a responsibility to protect people's identities, or rather their personal information. In this case, it seems to me that the cell phone number was read out live in court by legal counsel, and the feed is live. I think that there is a responsibility also to the actors in the court case to be aware of the fact that things are going out live, and in a sense to bear that in mind. Certainly, I think that once something of that sort, has got out, and I suppose that's also a lesson that people will learn going forward, I think that there will be a responsibility on the media to do whatever they can to make sure that that kind of personal information doesn't reach further than is really necessary for the conduct of the trial.
Many people have said that the media attention on this trial, the incredible media attention, could possibly sway things. But considering we don't actually have a jury system, do you think that this could happen?
Well, I mean, that is exactly the question that was before the court that considered the media application to broadcast the hearing, and they will have taken into account, any possible impact. And as you say, we don't have a jury system, and so therefore, one would imagine that the judge and her two assessors really should be able to, in a sense, remove the kind of clamor from outside the courtroom, from what their considerations as they conduct the trial, and should be able to conduct it in a strict accordance with the rules of justice and to be fair to all concerned. Of course, as time goes on, we will see how things unfold. I mean, I was struck on the first day, I think it was, when one of the witnesses said, well, this is his or her version, which he is aware, or she's aware, I can't remember which, contradicts something that was said earlier by witnesses. Now, in the traditional sense, witnesses in a court case do not hear previous evidence. So this is this does, I think, change the dynamic of it. Whether it will affect the outcome, I seriously doubt, and certainly that would have been something that the initial court that considered the media application will have taken into account. And of course, one has to remember also that what is being weighed up, that there are two very important principles being weighed up here. On the one hand, of course, there is the absolutely critical need for an accused to have a fair hearing, that nothing should be done to infringe on that person's rights. On the other hand, there is the public's right to know what's going on. Our justice system is based on the principle that court cases are conducted in the open. Court proceedings are open to the public. There are some exceptions, but as a rule, they're open to the public precisely for that reason. Justice needs to be seen to be done. In this day and age, with a scale of interest, it has to be via the media. So those two, in a sense, those two principles needed to be weighed up, and the court in the end came up with a solution which they felt at the time balanced those, and I think it was a good solution. As I say, who knows how things will unfold and what will happen in future, and certainly I don't think that there was a clear focus on the possibility that somebody's cell phone would be broadcast to the world and that various people would take action on the strength of that. As things will unfold, there may have to be adjustments made. It's new territory, this.
Thank you very much for joining us, Prof. Kruger.